Good morning, everyone.
Good morning.
Thank you for your patience. Apologize. I started my hearings at 8 and had a court reporter get ill, and so it was late and had to use interpreters, and we had to wait for them. So anyway, that's my gripe. Anyway, so let's get on the record then in cause number DCM-21-02100. And let me see. Is the defendant present?
Yes, Your
All right, let me see. I don't quite see him. Yeah, where's he at?
He's with me, Your Honor, and
Let's see. All right. Okay, let's hear an announcement from the state and defense, please.
State's ready, Your Honor.
defense is ready, Your Honor. Should go for the defendant.
Okay, Lori, good morning. Can you hear everybody?
I can.
Mr. Goebel, you're kind of you came off a little bit garbled.
Okay. Can you hear me now? I may have to reconnect.
Yeah, much better.
Okay.
All right. Okay, I guess the first matter I want to take up, I guess, would be the any rulings I have not made heretofore. I granted, I think, State's Exhibit number 45 and signed an order to that respect. The only other thing is the state's expert, the request for a state's expert. I told you all that I'm going to grant that, and I'm going to grant it. And the only thing we need to hash out now is the restrictions that's going to be placed on such an order, so it can be drafted properly. So it's my understanding the defense wants these restrictions. If I granted it, and I am, they want restrictions. They want the order within 3 days. Oh, no, I'm sorry. They want to know who the expert will be within 3 days of me signing the order. I don't know if you have an idea who you would get, Mr. Best. Any problem with that? They just want to know who it is within 3 days.
I just want to. Which motion was this? Which number?
Your motion. It's your motion for an expert.
It's my motion. Okay. To get notice from the defense of their experts.
No, they want to know. I'm granting your motion to have an expert examine the defendant.
I see. I'm so sorry, Judge.
Okay.
I'm so sorry. Yes, that's fine.
And they want to know who that will be within 3 days of me signing the order.
Okay, that's fine, Your Honor.
Okay. They want 7 days notice of when the exam is going to take place. In other words, when the doctor, whoever it is, schedules the examination, they want 7 days notice. They want to be present, but not during the examination, but outside the door of where the examinations take place, and that's what I would order. At any rate, that any problem with giving them 7 days notice, I guess you can stay in touch with whoever's going to do the examination, and they can tell you when they can do it, and then give them notice of it. 7 days.
That's
Any
fine,
problem?
Judge.
All right. They want okay, the examination, the scope of it. That's what we need to talk about. All right, future dangerousness, I'm going to allow it on that ground. They want it in the state. Are you asking on mental retardation as well?
Yeah, yes, Your Honor.
Okay. Anything from the defense on that? I can't hear you, Miss.
Judge, just a second. We're gonna switch audio so you can hear her better. She's got arguments.
Yeah, you're muted. Muted, Ashley.
I'm not muted.
Yeah, but can you?
Yeah, I can.
Your computer though too. Otherwise it's gonna.
Yeah, I'm gonna mute mine.
Off the record, just a minute till we work out the.
Judge, can you hear me okay?
Yes. Okay. Back on the record now.
Okay, sorry, we're all in the same room, so we have a bit of an
Gotcha.
echo. If
I
one of us
understand.
isn't muted and try to talk at the same time. So, Judge, part of the problem and the concern is at this point in time, we don't know who we're all presenting as experts and the scope of that expertise and what they will all be doing. And so if we have an expert going in and essentially conducting a fishing expedition into mitigation and trying to get through that information, at this point in time, we don't know what is all going to be presented. And LaGrone specifically limits any evaluation to what the defense presents and brings up. So at this point in time, we don't know what will be brought forth, and we would ask that it be limited to anything that we haven't brought up.
Well, I think a lot of that I'm going to take care of on some of the other orders, but I'm going to go ahead and provide that the examination shall be on two issues: future dangerousness and mental retardation.
And Judge, may I ask that once we receive notice of who the state's expert is, if we have a concern with their ability to conduct an expert or an evaluation that does not fall within their expertise, may we raise that issue before the court?
Well, isn't that I mean, yeah, you can raise it. I mean, sure, you can raise it. I'm not sure I'll entertain it because it's subject to cross-examination and things of that nature. You challenge the expert. You can challenge the expert before pre-trial, certainly. Yeah, I mean, that's your privilege under 705.
Thank you, Judge.
Yeah. So, okay. Video, audio recording, is that necessary?
Yes, Judge, we would ask for that so that we can ensure that the evaluation does not exceed the scope of what is ordered, but also so that we can ensure how the evaluation was conducted, what questions were asked, the manner that they were asked, that we can see how the defendant responded and acted. There's a lot of information that these evaluations occur through how they're answering questions, their demeanor, that sort of thing. And so being able to see that, to see what happens and have that documented, we feel is essential and important.
Well, since you're asking though that it be sealed and not be divulged until the appropriate time, how are we going to know all that if you
Well,
say
correct,
so?
Judge,
The report would be sealed. The audio recording would be sealed.
Correct, Judge, but just like we'd have a chance to look at the report, we would have a chance to review that as well.
Mr. Best.
Judge, I did speak to our expert that we're planning on using, and he had concerns about the video recording. Didn't have a problem with audio recording, just so you could document everything that was said. And again, it would be sealed. We wouldn't have access to it until such time as the defense raised a particular issue that would authorize us to have access to that. So we wouldn't object to the audio recording necessarily, but had some concerns about the video recording.
Anything else on that, Miss?
If the state isn't objecting to audio, I don't understand what the difference between having it video recorded would be. Instead of just audio, you have audio and video. So if we're doing one, I don't understand why we wouldn't be able to do the other one.
The only thing our expert mentioned was just not having any kind of, I guess, equipment, any kind of formal type of equipment that he could use to do an audio recording.
And
I'll
just
tell you what, this is the first time I've seen this, but I don't have any problem with the audio, but I do have a problem with the video. You can find out enough about the audio that your concerns can be addressed through the audio without the video. So I'm gonna order the audio, but not the video.
Yes, Judge.
The warnings, of course, they have to give the warnings. The expert to provide written report within 10 days of examination to the court, file it with the court within 10 days. Is that doable?
Yes, Your Honor.
It's fine? Okay. 10 days. No inquiry into the offense or extraneouses. What about that? The objection to that?
I
mean, I'm no expert, so I've never conducted one of these. I'm certainly, like I said, I'm no expert, but how do you talk about future dangerousness if, I mean, I guess you could do it with hypotheticals, but that wouldn't be near the examination of the defendant. How do you make a determination on future dangerousness without talking about the crime? I'll let y'all educate me on that.
And Judge, the whole purpose of the examination is to conduct what the defense does, to not conduct whatever examination they want into whatever. The purpose is so that they can have an expert who can rebut specifically what our expert does. So in terms of future dangerousness, that examination should be limited to the items that our expert talks about with Mr. Nicholas, or the purpose of their examination. And so at this point in time, we haven't had our expert go in and conduct that examination. And so to my knowledge, I can't say for certain whether or not they're going to go into those things. But if they do not go into those things, it's not appropriate then for the state expert to go into those things, as it is limited to the evaluation that our expert conducts.
So no expert, regardless of who they're going to testify for, would ever go into the crime itself?
And I'm not saying that, but I'm saying if our expert does not use that as a basis to conduct their evaluation, that doesn't open the door for the state to then send in an expert who does get to open that door. It's limited to the scope and the information that we present in the evaluation that we conduct. So if we don't present and discuss with our client, the expert doesn't, the facts of the case, the state doesn't then get to go in and conduct an evaluation and open that door and have that extra information conducted if that's beyond the scope of the evaluation that our expert did.
So you mean an expert, regardless of who they're going to testify for, could make an opinion, give an opinion on future dangerousness without going into the facts of the offense?
Correct.
Just on past history?
Okay. When you're looking at future dangerousness, it's whether or not they're going to continue to commit criminal acts of violence in their society, which
Right.
looks at the prison, their behavior and their conduct in jail, talking to the jailers, doing different assessments for their risk in the future. So it doesn't necessarily mean that they're going to talk about the offense itself. And that's the jury can conduct that inquiry and have that as part of their purview and their assessment as to future dangerousness. But that doesn't mean that an expert is necessarily going to sit and talk with the defendant about it.
All right, Mr. Bess?
I think that's probably right, Judge. I think that's a correct analysis. We can, and certainly, the nature of the offense, the jury can consider that regarding the issue of future danger. But I think that I don't know that our expert can specifically go into the facts of the case with the defendant during his evaluation.
Yeah, it's a fine line. Okay, all right. Very
Uh,
well. So
and-
ordered. Yeah, go ahead. You were going
I was just going to say, as far as extraneous offenses or bad conduct or anything the defense might, anything the expert might have regarding the defendant's past history, I'm not so sure about that, whether the expert should be able to discuss any of that with the defendant. It's not relating to the specific offense in this case. So you'd mentioned whether the defense expert should be able to talk to him
Yeah.
about.
that's what they have in their motion. They want to limit it in a certain way. So they extraneous offense, they don't want to go into extraneous offenses as well, which yeah, well, that's what I'm thinking, but what do you say?
We would ask that our expert be allowed to talk to the defendant about extraneous offenses or bad conduct or any of the evidence that's contained in his records that might be useful to the expert in kind of evaluating the defendant.
Response?
And Judge, that raises many of the same issues. And a lot of those extraneous offenses are extraneous offenses because they could be criminal conduct, whether or not they're charged. And then that's going to raise issues. Do we need to get Mr. Nicholas an attorney on those cases so that he has someone who can advise him of his rights and those? We don't represent him on those charges. We represent him on the case at hand. And so you're running into much of those same issues. And again, just because there are those extraneous offenses, we're talking about whether or not he's going to be a future danger in prison, not whether or not he smoked marijuana, which in prison, they're safe. They keep drugs out of there. Marijuana isn't necessarily something that a future dangerous expert is going to be looking at because they're not going to have access to those drugs while they're in prison. And so it raises even more issues if we look at those extraneous offenses. And again, not something that the expert is necessarily going to need to evaluate or look at to conduct an assessment as to whether or not they're going to continue to be a future danger.
Okay. I am going to allow them to and I'm at a loss here because I'm not familiar with how they go about their jobs at determining future dangers, what kind of questions they ask them, what they go into. So I'm at a loss to know about that. But it seemed like with extraneous offenses would be an area they would be looking at because I guess they could say, well, past conduct will determine future conduct. That's one school of thought. How do you can't do it in a vacuum. So, the protocol that they use, are you familiar with the protocol that they use on these issues in doing these examinations?
I don't have that specifically at this time. I think if you're willing to, the best option would be to say if the defense expert does evaluate those issues and does discuss those issues, then the state expert may have a chance to do so as well. But if the defense expert does not go into extraneous offenses, then the state expert can be allowed to.
Well, as a practical matter, how does that happen? I mean, if we're gonna say if you present an expert and he's going to have to wait to do an examination until after? Is that what you're saying?
That ultimately, that would be my request, is that an examination not take place until after our experts have testified.
Okay, or he could listen to, of course, the expert's going to be in the courtroom listening to each other. They could testify as to what they hear in there. It may not be in the report, so that would be it wouldn't be in the report, but something like that would only be fair that they'd be able to opine on what they heard the experts say in court.
And that's the tricky part, and I think LeGrone addressed some of those issues. Is the court authorized the examination of the defendant ahead of trial, so that when we got into trial and when the defense expert did testify, we didn't have to have a big long recess to.
No, we're not going to do that.
Right.
We're not gonna do that.
And so that's
so this is what I'm going to do in that regard. I'm going to not have him ask him about the facts of the offense. But other than that, I'm going to allow him to perform the examination according to professional protocol in these type of cases. And if that involves asking about extraneous offenses, then so be it. Okay, so in the order, they're to conduct examination according to protocol in these type of situations, based on their experience, and but not to go into the crime itself. But if extraneous offenses is part of it, then they're allowed to go into it. Okay, so when we prepare an order, and I'm going to have the defense prepare the order. Well, it's granting the states you would have to put together, since it's really, I'm granting it in your favor, but I'm putting restrictions on it. I guess it's a little bit of both. So who wants to prepare the order right now? Well, we haven't finished, but who wants to prepare the order?
I can do it, Judge, if that's fine, because a lot of this was in our response, so I can just take that and then tweak it with what you ordered on the record and then send it to the judge for his review.
Okay, any problem with that?
But that's fine. Thanks, Ashley.
Thank you. Appreciate that. They want me to seal the report, which is granted until it becomes relevant to use. Before I seal it, do you want me to examine it for any exculpatory or mitigating information?
Yes, Judge.
I don't have a problem with that. Yeah, okay. The experts are exempt from the rule that either side, both sides. That's granted. If the defendant refuses to be examined, then that fact will not be divulged by the jury to the jury. Of course, that comes up, and we don't know what's going to happen. But assuming that he's not examined, he doesn't want to be examined. That's his privilege. But then the expert, presumably, the state would seek to do it by hypothetical questions. So just to let you all know, that could be out there, taking into account all the possibilities. All right. Okay. So anything else, defense on that issue?
No, Judge, thank you.
You got enough information to put together a good order then?
Yes, I believe so.
All right. The defense motion number 12, dealing with the records of the personnel files and internal investigation files. Why do you need personnel files?
Your Honor, I think hold on a second. Yeah, I think we may have that worked out. We've sent some alternate language to Mr. Beth. I don't know if you've had a chance to review it, but it was speaking from.
Hold on. Yeah, you're garbled. You come off garbled, Mr. Goebel.
Can you hear me on Ashley?
No, it's still sort of garbled and
Here, just mute yours.
Now, how's that happening if y'all are in the same room?
No idea.
That's the device. All right.
Um,
Now you're fine.
I've had some issues with my laptops, Your Honor, just to be
Okay.
to be clear.
All
Two of them gave out on me in our last trial. So, yeah, we were on motion number 12. I'd sent over some proposed alternate language for that paragraph F that was used in a recent murder trial here in Tom Green. So when Mr. Best has a chance to review that, I think we'll be able to submit an agreed order for that one.
Mr. Best, have you reviewed that?
Judge, I have, and so, previously the defense, had asked for all personnel files for law enforcement witnesses, basically. And in the proposed order, it says shall provide, let's see, shall provide personnel records containing information outlined in the below list of things, and it basically lists anything that might be exculpatory or Brady material, and we're fine with that. My only problem is the way it's worded right now. The proposed language that we're working on right now says shall provide personnel records containing information outlined in the below. I just want to make sure. I guess I agree. We should not be required to provide a personnel file for a law enforcement witness. We feel like it's appropriate for the agencies to go through the personnel files of proposed witnesses and identify any potential Brady material, which is our obligation anyway. And we would request that anything that's identified be provided to the court for in-camera inspection, and then be turned over to the defense if the court believes that it's in fact Brady or exculpatory material. Does that make sense?
And I think that's what we have now, Judge. We may need to tweak the language a little bit before we send it to you. But yeah, we've reduced it to just those things that would obviously be Brady and exculpatory for this specific motion, and we are still anticipating an in-camera review of the materials before it's turned over to defense.
Okay. So it looks like y'all can work out the language of that.
I think
Yes, Your Honor. Hopefully we can send, maybe this afternoon, we'll be able to send you a final proposed order.
Okay.
and
So I'm gonna just note that counsel for both side defense and state have conferred on the language of that. It will be granted. The particular portion dealing with law enforcement personnel, you all are gonna tweak the language and put it in the agreed order, correct?
yes,
Yes.
Judge. And I remember we had a bit of discussion about this motion at our pretrial hearing, talking about all these motions. And as my notes show that regarding number 1 from this pretrial motion 12, I mean, the gist of 1A is we're going to provide them with TCIC, NCIC records for each witness. And that should cover all that.
Yeah.
And I believe we provided that for 99% of our witnesses already, and we've got that ready to go. We had a problem with B, and I think we discussed that. All records and information revealing prior misconduct or bad acts attributed to all states' witnesses. And my comment at that time was, and I think the response that the court discussed was not anything that's outside the realm of the state's knowledge or not in the TCIC and CIC. If I know about it, I'm going to tell them about it. But I don't know, a lot of these civilian witnesses, I don't know what outside their TCIC, NCIC, any prior misconduct or bad acts. Does that make sense?
Yes, it does.
Um,
Mr. Goble, what do you have to say about that?
Your Honor, the opening paragraph limited to, has the limiting language from the Michael Martin Act within the possession, custody, or control of the state, or the existence of which is known, or by the exercise of due diligence could become known to the state. So I think that's our intention, is the things that are envisioned in the Michael Martin Act, is the things that they know about. No, and I'm not certainly suggesting that Mr. Best would, I don't have any reason to think that he would ever willfully leave something out that he knew about. So it's just really language. We're trying to track the statute and not put any extra burden on him, but we are trying to make the appropriate record that we need for a capital case, that we have made the appropriate requests and sought out orders to follow up on the notice that we've requested the discovery, Your Honor.
Okay, so it says to 1B, then it was the state shall divulge all information and records that they are in possession of or aware of.
The way it's drafted, Your Honor, it's the opening paragraph is the limiting paragraph that talks about within the possession, custody, or control of the state.
Mm-hmm.
And then the existence of which is known, or by exercise of due diligence could become known. And Mr. Best is right that when we've addressed this on the record, both with Your Honor and with the prior judge, it was in terms of the NCIC, TCIC, and anything else that they know about or have come into their possession. I think Mr. Best is right. It would probably be Brady material as well, but we have, like I said, just in our due diligence, separated these orders out and requested each thing separately so we could try to make a good record.
All right.
and I think that's fair, Judge. I see
Yeah.
the limiting possession, custody, and control of the state. So that's good. That gives me some. I just want to make sure I'm not overlooking anything. And then, Judge, the last thought is how, I guess my thought on how to provide this to you. We'll get the order prepared that we agreed to. We'll submit that to you, and then I've got law enforcement pretty much ready to hand over whatever they've got. Do you want it all on a thumb drive, or do you want it printed out, or how would you like it? I'm not necessarily going to be involved in that process. I'm going to have my law enforcement provide it directly to the court, so that it can be reviewed and turned over to.
Well, I don't want to print it out. That
Okay.
I don't want. So
Okay.
if they could put it on a thumb drive or some secure way, like a Dropbox. I have access to that.
Okay.
Or some other secure way that they can get it to me. I can pretty much look at it on the computer.
Okay. I'll figure that out. And who can I coordinate or have law enforcement coordinate with on your end, as far as how to get that to you? Do you have a court administrator that we can use? Or
Me, myself, and I. Sylvia's been helping me, but I don't want to impose on Judge Weatherby. She's been helping me a lot. Hi, Sylvia. And so I don't know if she would be willing to. You can coordinate it through her. Well, Sylvia, you're muted. Would you?
I can be there. Judge Weatherby is okay with that.
Okay.
He already asked, if you asked, to say yes.
Okay.
I'll coordinate with Miss Noriega and about getting those records to her, and then she can get them to you.
We can do that.
Okay. I appreciate it. Thank you. All right. Number C has to do with promises and considerations. That's pretty self-explanatory.
And we talked about that in court, Judge, and they mentioned that they weren't interested in things like witness expenses or things like that, but they were interested in any kind of offers of consideration associated with someone's testimony, and then of course expert witness fees and schedules and that sort of thing.
All right. D has to do with documents and records, memoranda that deal with that, promises to witnesses. Existence and identification of each occasion in which the witness has testified before the court, grand jury, or other tribunal. Any problem with that?
And we talked about that before as well, Judge. I had raised a concern. We provided them with Terry Eaton's name. He's the only witness that testified at grand jury regarding the case. And then I had concerns about my knowledge or access to any kind of other tribunals that might somehow be related to this offense, because I just don't have any idea if it's not in the criminal world. The defense mentioned something about maybe a workers' comp hearing or something like that, and I hope that we're all on the same page, that I'm not aware of any other hearings. That's not in my possession. So I'm not sure what I could provide on that in that regard.
You all want to shed some light on that? I mean, if you're going to be honest, like hearings before the Workers' Compensation Commission.
I think we're kind of on the same page, Your Honor. I think if it had been something that the state was made aware of, we would want to know that, but if not, I know that one of the individual who's the alleged victim of the assault would have been a city employee at the time, so if that wasn't part of the materials that the state has in their custody or control, then I think that was just an example of what we were thinking.
Okay.
Because a lot of times in a case like this, where you have somebody who's on the job while something happens, you'll have some sort of crossover, and the state will be aware that there's additional medical records, additional whatever. But if there's not, there's just not. We do have some limiting language at the end of that paragraph about it's related to the defendant, this investigation, or the facts of this case. But so I think that's our intent.
Okay. Okay, and F we talked about already.
Yes, Your Honor.
So the motion 12 is granted, subject to the restrictions and limitations that we talked about today.
And we'll provide you with an updated agreed to order on that, if that's okay, Judge.
Yes, the defense said they were going to prepare it, right?
Yes, Your Honor.
We're still tweaking the language, and yes, we'll submit something to you hopefully this afternoon.
That sounds good. All right. We ever talked about the questionnaire. Let me put this way. Is there any other pending motions that you want to address that we need to talk about this time? I granted 45 as requested already, signed in order. But are there any other pending motions that y'all can think of that we have not talked about before?
Not that I'm aware of, Your Honor.
Okay.
Not that I'm aware of, Judge.
I'm not going to foreclose you on them. If you think of something later, let me know, and we can take them up when I go up there in April. April 21st. The questionnaire, I don't know if we ever addressed the questionnaire. Have you all been talking about a questionnaire for the potential jurors?
We have, Your Honor. We had given a draft to Mr. Best. He is going to provide us with some comments this week, and then we'll move forward from there. We're hoping we can talk about this later, but hopefully at one of our upcoming pretrial hearings, we'll get to address it, if that's okay with the court.
Okay, maybe we can take it up when I go up there in April for the competency, if you would.
Yes, Judge. And yeah, we're working on it, and we're gonna meet on Friday, I believe, to discuss it, and we should be able to get that thing. It's awfully long, but we're gonna try and narrow it down as much as we can.
Yeah.
Yeah, I think if memory serves me correctly,
Don't make it too long. 10 pages will be fine. But yeah, I'm serious. Yeah, you're going to have people staying there and filling out these forms all night long. Pick your best shot. I'm going to look it over, and if I feel the need, that I'm going to pare it down.
And Judge, it might, if you're willing to, it might not be a bad idea for us to get together and go through it, but I can tell you it's pretty long and it might take us a while to do that. So whatever you want to do, if you want to go through it.
Right. Yeah, be prepared to talk about it when I go up there April 21st or sometime that week.
Judge,
Because we're not going to have a book. You're going to pare it down to the last one. I'm going to look at others I've used in the past and see whether those are sufficient. Yeah, so
Your Honor, I don't know if you want to take this up right now at this time, but I have one of our security guys that was summoned to be a juror, and he's requesting to be excused just to help them plan, because he's one of the security here that is going to help with, he's not sure where he'll end up, but we have several jury trials scheduled, and that we're really needing the manpower.
okay, well, that's a work related, so I'm gonna say it's denied if the parties want to agree. If both sides agree to him being excused, then I'll approve that agreement. But short of that, it's work related. In that regard, it gets us into the summons, so you can tell them that these attorneys will tell me when I go up there whether they give them the number. Juror number and everything. I have excused some jurors having to do with mainly vacations, prepaid, itinerary has been provided for the 28th. And we're going to talk about the summons and all that. And how that works. But
I will email you his number, name, and all that.
may mail it to them.
Okay, I'll email it to
They're going to try to reach agreement on it. If they don't agree,
John and Stephen. Okay.
Denied.
Okay, the
Yeah, it's
attorneys
work
will. Okay, it's up to the attorneys.
Yeah.
And okay, one more thing.
Yeah. Hold on. Well, I'll get to it. Yeah, I've got granted excuses for vacations and some medical hardships where I've gotten doctor's reports, things of that nature. They were truly only one have I granted for work related and had to do with a surgery team having to do with open heart surgery that are on rotation for that particular day. And that
Do you want to see those? Or
No. I've been seeing them. I've been reviewing it.
Okay, with Stephanie
Yeah.
Kitten. Okay.
Yeah,
Perfect.
definitely been sent it to me. So just to let you know,
Okay, I appreciate
make
that.
objections to that one. Other than that, I've not made any other work-related excuses. Just to this rotation surgery team that does open heart surgeries, and they're the only ones that can do that during that period of time.
One more thing, Judge. Well, there'll be
We haven't so we haven't finished.
Okay.
I'm gonna ask the district clerk's office regarding the procedure regarding the summonses and how you do that. And here's what happened, Stephanie. I told you that I wanted to do all the excusing. I didn't want anything excused for any reason. I've granted exemptions and things based on my review of them, but and she sent me all those. There's one that's work related that I sent to y'all that a person's going on conference. It looks work related, and I'm assuming it's work related, so I'm not excusing her, subject to your all's agreement on her. But I need to know, when I started getting all these, Stephanie, I noticed that hey, there's no conflict with 28th. What's the problem? And so I brought that to your attention, and I see where you sent out someone just for the month of May, which is to me was unusual. I don't know it's the regular way you do it, but you had sent a summons for May rather than the specific date of May 20th. Yes. Can you explain
Yes. So the way that we process them, and we send out the summons for the whole month of May to get everybody to respond. And then once I have enough people to fill the panel that you requested, that's when they actually get the email notification saying that they have a specific day for them to appear at a specific location and a time.
Okay. Is that how it's normally done there?
Yes, sir.
In the county?
Yes, sir.
Okay. Okay. Yeah,
I
I thought it a little but if that's the way you do it, that's the way you do it.
Yes, sir. And I have already actually created the panel for your reporting date of the 28th. So every party, the defense has their copy. They picked it up yesterday. State's attorney has their copy as well. So I actually called and put on your panel 600 people. Because I did have several people where they had submitted that they had vacations during that time, but they did not submit any travel reservations or itinerary for my review. So I went ahead and increased the number just to make sure that we had more than enough qualified folks to report on that specific day.
All right. Defense, you have any questions of Stephanie?
I do, Your Honor. Uh, I guess I'm a little bit confused. So are there any other panels you're picking for the month of May? Is this one big pool and you picked all the
No,
panels out of it, or is it just
I created your panel is sole and your pool is sole and separate. I have panels for the month of May for the rest of my stuff, but they are two different colors. So your summonses are purple and my regular May summonses that I picked for everybody else is yellow. So that is the differentiation.
It's like a special veneer, I guess.
Yes.
Okay. Yeah, I'm the only reason, well, I'm asking too, obviously, because of the way Chapter 35 is a little confusing and contradictory some places, especially where capital's involved. So is there like a list of the total of everyone you sent the request to for May, but then those ended up being just the May 28th people too, right?
Yes. So I sent 3,000 summonses for the May capital special trial that we're having. And then I sent 3,000 summonses for my regular May trials because I pulled juries for all my justice of the peace, my county courts at law, and all my other district courts as well. So that was the differentiation that I came up with to make sure that you are a different color to not confuse the public and everybody else as well.
So how did we end up with the 600 we ended up with? Is that
It came out of when I sent out the special color, I sent those out at the beginning of March to make sure that we had everybody have enough time to respond and all of that stuff. So that's how that was created.
but I mean, you had more than 600 respond though, right?
I did.
Okay, so how did we end up with the 600? Was it then they're like a random drawing, or how did we
Yes,
end up?
it's a randomization through the computer. I tell the computer I need 600 people and the computer goes in and picks them all out.
Okay. Do you have any idea off the top of your head how many responded for our?
1,115. That's the last count that I had. It may be more than that now.
Okay, so for the 3,000 for the regular dockets, is it the
Yes,
same
sir.
process? You had X number of people responded
Yes.
and then
Yes,
and then
sir.
it randomizes it?
Yes, sir.
Okay, and that
Since it's on-
assigns them the number when we get the first 600.
Just a minute. Stephanie, since it's on the record, wait until Mr. Goebel waits because Stephanie's taking down. So just settle down. Okay. go ahead.
I'm sorry, all right, that's probably me talking over her too. So then the 600 plus we ended up with, that's the computer assigning a random number to them and putting them in an order?
Yes, sir.
And they were sent a questionnaire that they certify, right?
They were sent a letter that I issued that they go on and they do have to certify that they're telling the truth.
Okay. On the you were talking, I was a little confused when we were talking about excuses. Everyone who's asked for an excuse or applied for an excuse, that's been sent to Judge Aquila.
So, yes,
Did that include like the people who are disqualified for age or something else or not?
no,
Okay. So were there some of those that filed for disqualification already?
yes.
Okay. And what just refresh my memory, what disqualifications did you all accept? Was it age? What else? Felony?
Age, felony, children. If they have custody of guardianship of a child younger than 12. Misdemeanor theft. Trying to think.
Non-county resident,
I'm sorry.
a non-county resident.
Yes, thank you. Over if you're not age 18, over the age of 18, if you don't live in the county, if you're not a US citizen. If you are, exemptions are if you're a full-time high school student, or if you're a full-time registered and attending college or secondary education as like a technical school. If you're active duty military and deployed away from your home station.
And that's the same process you would use for the other panel as well.
Yes, sir.
Is there any process for verifying those disqualifications?
When it comes to age, I calculate what their birth date is, because the system, the computer system actually pulls that information from the Secretary of State. So I verify the birth date. As far as anything else related to that, it's what they certify is true on that questionnaire.
Okay. And then the requests for excuses that were sent to Judge Alcala, that would have been work-related, medical, or what else? What are we
Hardship,
talking about there? Pardon me?
hardship, hardship.
Hardships. Sorry, hardships.
Yes,
So the
sir.
hardships are the ones you sent to Judge Alcala.
And yes, vacations.
Do you know how many asked for the hardship exemptions?
I don't. I have a folder, but I haven't counted them up. No.
Okay. Have all those been sent to Judge Alcala already?
Yes.
Do you know how many ended up being disqualified from the 1,115?
Not off the top of my head. I don't have those numbers with me.
Okay. I think that's all my questions, Judge. Thank you.
Okay, Mr. Best, you have anything on that issue?
I don't, Your Honor.
All righty, I guess, what other issues you all want to talk about? We're gonna be at the convention center, not the convention center. We're gonna pick the jury in courtroom A for the competency. For the competency, we're gonna be in courtroom A, correct, Sylvia? You want to unmute?
That is correct.
Okay.
We're switching courts. Or we take the sub room, you take A.
Okay. Thank you.
You're
Whoever took the sub room. And have you heard from the 119th as to where we're going to actually try the competency? Do you know?
They are looking at leaving you there in their courtroom, and they're are going to be going to a different courtroom, maybe across the street.
Okay.
But they don't have a definite courtroom right now, but
Okay.
there's other ways to do it. Maybe Judge Rios can this one time go Zoom, do the pre-trials via Zoom.
Mhm.
And it's going to work out somehow.
Okay. Okay.
But you will go to his courtroom.
All right. Okay.
And Judge, are you gonna need me to assist you with a jury charge? Are they gonna send you a proposed one? Or we wait till the actual day? You don't want to be prior to?
Yeah, well, we still got time for that.
Okay.
See jury charges.
Okay.
Not that long, nor complicated, is my experience. I have one from way back, but I'm sure it could be tweaked, and I'll certainly ask for inputs of the lawyers of state and defense in that regard. Sylvia, you had some other matters that you wanted to bring up?
That was it, because Judge Weatherby was gonna get one for me if anyone
Yeah.
needed
If you
that.
got one, we'll certainly look at it. If you have a proposed one, certainly we'll look at it. If y'all, I don't know if y'all tried,
Okay.
but It's been a while since I've tried a competency.
It's been a while for us too.
Yeah.
We're gonna go learn from you.
Judge, I do have some questions.
Okay, Amber.
So, are the day of the jury selection on the 28th, are we going to have a jury, sequester the jury? Not allow them to leave during lunch? Or are they going to be allowed to leave?
For lunch, you mean?
Yes.
Yeah, I mean, let's see. I got to do my voir dire as required. Counsel of State and Defense are gonna give a short introduction of themselves. Then I don't know if that's going to get into the lunch hour or not. In the past, it's well, in my experience has been close, where I didn't let them go to lunch, but I can see where we might need to do that. It's a large group. That's the only problematic thing. It's a large group to let them all go and have them all come back. You know, some of them will say, Judge, I swore you said we could go. We were gone for good, which I'll make it pretty clear they can't, but some of them don't show back up. So my feeling is I would like to get it all done and then let them go to lunch, even if it takes time. What time are we set for on the 28th? What time are
9
we set?
o'clock. We have the jury coming in at 8:30.
8:30? Okay. You know, I'm thinking we can get it all done. It depends a lot on how long the questionnaire is.
And Judge, I talked to Allison Palmer a little bit about this from their capital murder with Dela Cruz. And I thought she told me that they may have catered, just have like little box lunches for the jury, because if you're talking about 600 people and letting them go to lunch and then getting them back and making sure everyone's there, and that just becomes a nightmare,
Yeah.
from what she said. And so, and I think Mr. Goebel and I wanted to talk to you a little bit about voir dire and what we might be able to talk about in the general voir dire besides just introductions, in order to hopefully save time when we get to individual voir dire. And so I guess my suggestion based on Allison's recommendation would be that we try and figure out a way to cater some kind of a lunch for them so we can keep everybody there and make things move along as efficiently as possible.
I think that's a good idea.
Okay.
And I know courthouse
It
security.
accomplishes what I want to accomplish, and like I said, sometimes they all don't come back, and it's a problem. Yeah. But no, let's plan on that. Let's do that.
Okay. And do we need to declare the convention center as a courthouse? For the
Yes.
courthouse?
Yes.
And do you
An
need to do
annex,
that, or do
an
we?
annexation.
Okay, do you need to
Yeah.
do that, or does the commissioners?
I don't know. Somebody's got to put it for the commissioners, the Tom Green County commissioners.
Would it be Tom Green or would it be Concho?
Well, Tom Green, since it's transferred there. It wouldn't hurt to have both.
It's gonna be Judge Weatherby, Tom Green.
Yeah.
You know what? I think he
Green.
might have already done it.
Yeah, I've talked to the judges.
I think somebody
about
did
that,
it.
and,
Yeah, it's done.
would you check, Sylvia? But yes,
I will confirm that. Yes, sir.
I want to get it annexed for this case for that day only,
Okay.
and that's all.
Okay.
If Concho County wanted to do the same, then it certainly wouldn't hurt to have them annex that
Okay.
as part of the Concho County annexation as well. To make
Okay.
sure,
We
please.
can do that.
You think you can do that, Amber?
Yes, sir.
Paper? And just some resolution to
Yes,
annex the convention center for this purpose.
Absolutely. That will not be a problem.
Tom
And I
Green County.
think we had talked about, we weren't sure about bailiffs. Sylvia, do you know anything about bailiffs for the 21st? Because I don't believe, Harry Free will be able to be there.
Security,
For the competency trial.
for the
on the
competency
24th.
trial, that's why they're really begging for Gabriel to have, for the SUG, Judge Goodwin, Judge Akala, and Judge,
Okay.
yes.
What's his name?
Gabriel, Gabriel Velasquez.
Velasquez. All right, state defense, y'all talk about that. If y'all can excuse him, do it. If you can't, you can't. And
But
I'll-
yes, Amber, we'll have security.
Okay, it was just bailiffs. I know they had talked about the security wasn't gonna be a problem. It was just bailiffs for the judge that day. Or for those 2 days of the competency.
Judge Akla.
yes.
I was just told this morning that Carrie Freed will be bailiffing some on the 21st, and Blanca De La Rosa will be doing the other. And Gabriel is on the May 28th jury panel, not on the April 21st.
So Gabriel's on the 28th?
He's on the May 28th jury panel.
Oh, so he's not
on
on
April 21st.
He's not for April 21st.
No, so April 21st, he will be available to help with the other juries for Tom Green County.
Okay.
Okay, so.
Okay. All right. Well, all right. So forget that.
And I just got a message from Blanca. That is correct. She will be with you.
For the April 21st?
Competency.
Okay.
Right, Vicky, is that what you got too? Vicky, is that what you
That
understand?
was the information I got this morning from Debbie Lamb with Judge Rios' office, that it would be
Perfect.
Carrie on certain days and
And
Blanca
then
on
Blanca, perfect. Mhm.
depending on how many days it goes, because Carrie is tied up with Judge Rios on some other trial. So Blanca will fill in on those days.
I think those were my only questions that I had.
Anything else that we need to go over?
We've got a few more things, Judge. I apologize. I know it's going into the lunch hour.
All right.
Mr. Goebel and I were talking about on the competency trial. Vordaer, do you have thoughts on that? How long we'll have to do our Vordaer?
All right. I would say about 45 minutes aside.
Can I indulge the court for an hour for each side?
I would say prepare your presentation for 45 minutes. If you forget something or if it won't quite suffice, that you approach a bench and I'll
Yes, sir.
consider another 15 minutes.
Yes, sir. Let's see.
Let's talk about what we're going to tell the panel during our voir dire. That's very limited as to what they're there for. I can see some of them wanting to know what he's charged with, which is not relevant. They're limited. They're in scope, and the people that want to go off on tangents and want to know everything, they wouldn't be good jurors. So, suffice it to say, we wouldn't be here if we wouldn't charge a criminal offense. But as far as the competency is concerned, but their job is very limited to answer those questions, and those questions alone is whether he's competent in the relevant questions that pertain to that issue.
And Judge, one thing that Mr. Goebel had talked with me about is part of the discussion about competency and whether they understand the nature of the proceedings and can communicate with their attorney is, and like the range of punishment for the offense. I guess, are you expecting that we would be talking about those things in very general terms? Like, did you evaluate the defendant and he understood the charges against him and he understood the punishment range for the charges against him without talking about what those are? Does that make sense?
Yeah, I can see where it's get close. Yeah. Mr. Goebel?
Your Honor, the question we had is specifically like, even if and I understand the court not wanting us to mention it being a capital case, but capital are different. And we've already got a schedule for the trial that's going to take us through the whole summer. I don't know what your opinion is on whether we can say it's capital or if we can at least just say that it's going to be either complex or specifically to say that because of its complexity, it's expected to take this long, because those present different demands on someone in the situation, whether we're talking about a half an hour trial for a speeding ticket versus 7 weeks of picking a jury and another 3-4 weeks of an actual trial itself. Those are different levels of stress on an individual, obviously. So I don't know how specifically if we need to avoid the word capital, but as Mr. Best is talking about, use general terms for this trial is not a one-day affair. What's the court's thoughts on that, I guess?
Well, my question is, why would you want to even get to that point? And after talking to him about it.
Well, because it makes a difference to the experts, what we're actually expecting him to be able to, with the issues he has, what he's able to do is different than what someone else may be able to do. And the issue for competency, it's obviously fact specific, it's defendant specific. It's whether or not he'll be able to assist us with his defense, whether or not he'll be able to maintain communication with us over that period of time.
Yeah,
So,
I can see mention to him because of that it's a complex case. It's a serious case, those type of things, but I hesitate to allow the word capital murder and things like that to get into it. We won't even get a jury.
understand.
We need some focused people that can answer those specific questions, and you develop. I understand what you're talking about, that it's a long, complex trial, and the person may not be able to, under that stress, handle it in the same way another person would. I get that, yeah. So with those restrictions, yeah, you can go into it. It's complex. It's a serious case. It's going to take some time. If we go to trial, how would that affect him? This, that, and the other. But yeah, I'm going to hesitate otherwise to go into the case or the offense or any of the facts.
Your Honor, do we have our competency panel yet? Is that coming from the other section? Can we check on that?
Competency panel?
The jury panel for the competency trial.
What about that, Stephanie or Ms.
I
Hubbard?
do have it. It is in my office. You are welcome to come by and pick it up.
Thank you.
You're welcome.
And I think we had tried to get about 100 people.
I called 135, Judge.
135, okay.
And we'll be running criminal histories on those as soon as we get them, and we'll provide those to the defense. Do we already have an order on that? To provide the criminal histories for the jury panel? A motion and order?
I don't know if we have one specifically for the competency. We can get that done this afternoon too, if you want, Mr. Best.
Yes, we'll get that. We're happy to provide it. We just have to have an order to be able to release it. So we'll just run TCIC and CIC on each one and provide that to the defense. We'll get the motion and order to the court this afternoon, hopefully. How about this? I just thought about this, but this is so unusual for me because I'm used to going first and last and whatever. And this is different because it's the defense's motion. Will they be going first in voir dire as well?
Yeah, I mean, they have the burden.
Okay, I'm just wanted to clarify that. Is there anything else?
Your Honor, while he's thinking, what time are we starting that morning? 8:30? 8?
What
Time do you want us to be there?
They have been summoned to come, Stephanie. What time on the 21st?
I have summoned the jury to appear here at 8:30 in the morning.
Okay. Okay.
And so you want us there at 8:30, Judge, or earlier? Or?
If you could be there pretty close to 8:30, that would be great. Make sure we. And how do you do that, Stephanie? Do you check them in before they go into the courtroom?
Yes, sir. They'll be
right off the bat.
So they'll be checked in via computer, and then they will be told which I actually have a couple of panels coming in that day, so they'll be checked in and told which courtroom to report to.
Okay, but once they're in the courtroom, we receive our panel in the courtroom. Are they seated in order or in a particular order? Or are they seated just generally, and then we we mix them up again after we qualify them, or how's that done?
So the way that my judges usually do it is they sit in random order. Once they're done with exemptions, disqualifications, and any excuses they bring to your attention, then I take everybody that you've excused out, create a new list, and then we sit them in order.
Okay, yeah, okay, that's the way I remember it being done. Yeah, here they do it different, but they sit them in order from the start. And then you have some blank chairs for those who didn't disqualified, but yeah, but at any rate, yeah, that's fine. Anything?
Stephanie, will you have numbers, little number cards for each of the jurors to hold up?
Yes,
So
sir.
that'll be great. That's really helpful. And then the last thing two things. One is another pretrial hearing. We're wondering, Mr. Goebel and I were talking a little earlier about whether we could have another pretrial hearing maybe middle of May before we get right up on the trial, maybe the 12th or 13th, if that was possible.
Sure.
And I don't know what issues might come up, but issues do come up, and it's always nice to be able to try and identify those before we're right up on trial. Stephen, did you have any thoughts on that?
Yeah, Your Honor, we just wanted to hold a day for a pretrial if we could have it, just because we're sure something's going to come up between now and then. I'm thinking that we may even still be working on the questionnaire at that point. I had one other issue too, Your Honor. If you're okay with scheduling that date, I got one more thing.
Let's set that right now. How about May 12th? It's a Monday, or May 13th, either one.
May 13th is clearer for us. We could do the 12th, but we've got a few things already set that day.
May 13th. Let me see what How about May 13th at 11:30 a.m. And I said it then because, of course, here it's an hour earlier. So if I have anything in the morning, I think if I had another 30 minutes today, I could have finished everything and not been late. But at 10:30 here, so that would give me time to finish my morning things that I have. How would that sound? May 13th at 11:30 Central Standard Time.
Yes, Your Honor.
Let's set that as let's call it a final pretrial. May 13th at 11:30.
Did
Okay,
you want
Mr.
to do that via Zoom?
Yes.
And Judge, the last thing I had on my list was, and maybe something we can talk about later, but it had to do with General voir dire on our capital murder trial. And I know
the scope of what you want to talk about.
Scope and length of time we have to talk to the panel. I guess just in a regular trial, the judge admonishes about burden of proof and all kinds of different general things. And then we generally do some voir dire on who the witnesses, do you know any witnesses? And that can take a little while. But we can have, we'll have a PowerPoint and screens with lists of people, just to try and get an idea if anybody knows anybody. And I'll tell you,
I've seen those handled in the questionnaire.
And we have a spot for that in our questionnaire as well. And I guess we could do that. That might make things a little more efficient. But the question that Mr. Goebel and I were thinking about is whether there might be some other, that we could have a little more time in general voir dire to try and maybe narrow down our pool a little bit for people that might not be suitable. Before we get to individual voir dire.
Okay, like what?
I don't have a voir dire pulled up in front of me. I'm sorry. I can pull one up real quick though, just to kind of get an idea. Give me
Well,
one.
here's the deal. I mean, I'm still inclined not to give you all much time there and then introduce yourself. And the reason is because they're going to be filling out an extensive questionnaire, the length of which is still up for determination. In that thing, you're going to know, you're going to get together and says, hey, let's not even waste our time on this one. Let's agree. And I expect you all to do that. It certainly is streamlining the process that you all look through the questionnaires and determine who you all, when in earnest, you can talk to that has a possibility of making the jury. They can follow the law. But and that's why I'm gonna rely on y'all to do that and advise me. Judge, we looked through the questionnaires. We don't think there's any point in talking to X, Y, and Z. And we agree to excuse them. Fine. Then let's call the next ones. And so do it that way. I hate to bring up anything when you got a pool of 600 people. You know how the crowd mentality, if you're going to lose a lot of them when they don't think for themselves rather than independently. They're thinking independently when they fill out the questionnaire, certainly. And so if you ask them any questions during your board hour there on May 28th, then that are real sensitive. I mean, we're going to flesh out some, they're going to know something about the offense, and I need to know from y'all just exactly. I got to tell them whether there's any publicity that they've heard about, read about, pertaining to this offense. So I need a blurb, a summary of the incident to clue a knowledgeable person as to the offense. Have you heard about this? Have you read about this incident? So we need to tell them something, and I'll leave it to y'all to tell me how much you want me to tell them at that point. But the point is, I don't see the need for a lengthy voir dire. Again, and then y'all haven't given me a reason yet, so I'm still waiting to hear that.
Sure, Judge. I'm kind of looking through. I'm anticipating that self-defense might be an issue in this case. Questions about a potential juror's ability to follow the law. And those are things we can talk about in individual voir dire for sure, and we will. And maybe that's better handled in an individual voir dire than general. I was just trying to think of things that we could talk about. You're going to talk about the burden of proof. Sometimes we'll want to make sure they understand the difference between beyond a reasonable doubt and beyond a shadow of a doubt or all possible doubt. Let me see. We talked about witnesses and the witness list, and we can put that in the questionnaire. I'm looking through one of my other voir dires to see what we might want to talk about. You're going to talk about phases of trial, so that shouldn't be too much of a thing.
Well, the statute sets out what I'm supposed to talk to them about, and that's exactly what I'm going to talk to them about.
Yes, sir.
I think the defenses and things like that, I think it's better individual.
Okay.
Yeah.
Okay.
I really think it's better individual. If you can think of anything, or let me know what you want to talk to me about, and I think it would streamline it and things like that. That'd be fine. But like I said, other than introduction,
sure.
I don't think it's. I have a plan on how I'm going to do it, and so it's pretty comprehensive. Yes, Mr. Golden.
Your Honor, for the record, we don't have any objection to more time being taken in general voir dire. The issue is that most of our time in individual is going to go towards the death penalty and, like you said, affirmative defenses. the general, with a group this large, you're right, it can be unwieldy. All we can do is bring up the general issues, write down the number of whoever has an issue, and then we can address that in the individual. That would be the idea of how to streamline it so we don't get into individual and get sidetracked on somebody who doesn't believe in the Fifth Amendment or doesn't believe in beyond a reasonable doubt, something like that. If we know that's going to be an issue for someone ahead of time, it just going to add something. You're right. A lot of this should be covered in the questionnaire. So I think the questionnaire, is more important that we get that information from them individually filled out as earnestly as they can. But like I said, overall, I don't have an objection to, I think you told us 15, 20 minutes. I don't have objection to a little more time than that to get through a PowerPoint just as it's kind of the introduction to us and to identify any issues that we're going to have to address in the individual that we wouldn't normally, because normally, obviously, you've been through this before. Normally that individuals a lot heavy focus on the punishment phase and things like that in the penalty case.
And defenses and things like that. So the PowerPoint, I'd like to look at it before you show it to them, if you could. I'd like to see it.
That might be a good next step, Judge, if we could both submit something to you and give you an estimate about how long we think it would take to get through it. And then you can make your final decision, whatever you want to do.
All right.
Judge, I had one more last issue. Especially Vince wants to know when you want our PowerPoints. Is there a particular time or just as soon as we can get them to you?
When you can get it to me.
Okay. The last thing, Your Honor, is as the jurors are coming in on the 28th, we would like to be able to take photographs, and so we'd be able to attach it to our questionnaires whose people are. It's just going to be tough to remember everybody without some way to identify them. We talked about possibly driver's license photos, but a lot of times those are out of date or just awkward. So, I mean, that's what we've done in the past, is had some sort of photograph. And I think on Dela Cruz, it was the clerks that did it, but they let us know yesterday they don't have the equipment to do that anymore. So I wanted to get the court's permission for someone on my staff to do that as people check in.
I'm not going to allow photographs. I'm going to deny your request.
Judge, I guess I'm going to chime in a little bit on that, and that's certainly, if you're going to deny the request, that's fine. That is, they did that in Dela Cruz, and Ms. Palmer indicated that it was very helpful. Like Mr. Goebel said, we got a huge panel, and I think the clerk's office took a photograph of everybody when they came in and attached it to the questionnaire so that we could have put a face with the name and the information. So, I mean, Vicky, were you part of that at all, that process?
But listen, if y'all agree to do it, that's fine, but you do it on your own. I'm not going to put the clerk's office responsibility for that. That's y'all's business.
Do you want us to?
It should be in a way that does not invade the privacy of the potential jurors. That you don't scare them to death that it's taking place. That they coordinate with the people checking them in. With Amber and the group she has, you coordinate that with them so that it's done in an unobtrusive manner. Okay.
Yes, Your Honor, and of course we'll turn those back into the clerk with questionnaires at the end.
I don't like it, but if y'all agree to it, that's fine.
And we'll see if we can come to an agreement on that. I agree with you, Judge. I don't want to scare him, and I wouldn't want my photograph taken. And I'd want to make sure it was, especially if I knew the defense was doing it, it might make me really nervous, or the state, quite frankly. So we'll try and figure out some way to work around that, understanding your concerns.
Yes, Your Honor.
If they refuse to take a picture, then I'm going to honor their refusal. So that's that. What else? Let's see, Sylvia, let's see, Vicky and Stephanie, during the process that we're going to the individual order, that's after May 28th, when we schedule them, the 2 weeks after the May 28th, when we start to schedule them. Before that time, I need somebody designated from the courthouse to be my right-hand person to call these individual jurors, to stay on top of them, know where they are, have their phone numbers, have a rapport with them. You're supposed to be here at this time. We expect you to be here. No, it's changed. You need to come right now. Those type of things. I need a person that can do that. So let's be thinking about who we can designate and have free to do that, because it's very important to me that I can talk to them. They have their cell phones. Says, look, call these 5 more people. Call the next 5 on the list, or whatever it takes, or given the circumstances and the fluidity of the process, they need to be available to do that. So if y'all could be thinking of someone that could do that, and we have the pretrial, we can talk about it then. But I do need somebody to be there the whole time.
It's up to Stephanie, but I can do it. I know Stephanie will be busy. Vicky probably be at another one.
I do, yeah. That's a big imposition.
I'll be glad to help.
on
You
your
tell
court,
me,
Sylvia.
Stephanie,
That's a big.
if you need me to help there.
Judge, we can probably take that on, and if we do need Sylvia, we can definitely use her.
Okay,
We're the ones that have all the information on the jurors.
sure.
So once we're told which ones will need to be called in, we can definitely make Stephanie be the one in charge of that. And if she has a reason to be out or something, then I can handle it. Sylvia can handle it. We can we can take care of that. Not a problem.
Okay, all right.
But we'll put Stephanie as your main point of contact on it,
All right.
because she knows the system better than any of us on how to contact them.
Fair enough. All right, what else?
That's all the defense has, Your Honor.
That's all the state has, Your Honor.
All right, then, just as a recap, we made some rulings regarding the state's experts and some restrictions and limitations. We talked about motion 45 has already been granted, order signed. Well, the questionnaire is still need to be revised and looked at. We need annexation of the convention center by Tom Green County, and it'd be helpful Concho County just to make sure. We need jury list for the competency trial needs to go to the council. Possible. Well, Gabriel Velasquez, he's summoned for the 28th, so it turns out not to be an issue. Final pretrial, May 13th, 11:30 a.m. by Zoom. Those are the major things I think that we talked about. We talked about maybe War Dyer and on the 28th. We talked some issues regarding jury selection on the 21st, April 21st, and how much the panel members should know in regard to the competency issues. That we need to be careful about that, talking to them about the offense that they need to. It's a very narrow task that those jurors will have in answering those questions, and we don't need to go beyond that. Okay. All right. What else? I think that's it. We're
Judge,
adjourned.
Sorry, Judge.
No, that's okay.
Well,
It's you're on your lunchtime. I'm
you're
not
hungry yet,
mine
huh?
yet. Well, I'm not mine yet. It's 11:46.
Motion 45, isn't that the taking pictures and the press and that sort of thing?
Yeah, right.
How I'm not gonna have any control over that. And I'm wondering about convention center. Any thoughts on how we regulate that for when we're at the convention center? Or during our competency trial, if somebody sees the press taking photos, will the security at the courthouse be monitored?
Yeah, it has to do with inside the courthouse, or I'm considering the convention center the same.
Yes, sir.
So outside, I don't have any control of it.
I'm just wondering who's gonna notify
who's
security.
gonna be the sheriff for that purpose?
Yes, sir.
Oh, well, law enforcement personnel. If I enter an order, I'm going to give them that order or see that they get it. And it needs to be enforced inside the facilities.
I think that answers my question.
I can, if I have the order, okay. I can draft a letter to the sheriff, in that regard. If there's no objections, that
That sounds-
this is the order regarding media in the courthouse or any annexed portions, being the convention center. And tell him that, and that this is the order, tell him that he needs to enforce it.
Yes, sir.
Yeah.
I guess I want to make sure that
Yeah, that's a good question. I appreciate you
Everyone's
bringing that
aware.
out because it certainly would have been an issue.
Judge,
Yes, ma'am.
it's normal procedure for the security for the courthouse that no cell phones, no cameras, no electronic devices at all are allowed in. So that's already normal procedure for the security. It will be the same, they said, at the convention center. They'll go by the same security rules. So that might help some with the inside, controlling the inside. No one will be allowed to bring in any kind of electronic device.
All right. So they already conditioned. All right.
that's all I had, Judge.
Your Honor,
Thank you.
are we able to go off the record for just a minute? Ms. Putchvinsky has an issue. Are we able to?
Ex parte issue?
Yeah, well, no, Mr. Best can be present. It's just a personal issue, so she'd rather not.
All right. Oh, okay. Okay. Yeah. Stephanie, Laurie will go off the record.
Play musical computers today. So my only request, well, not really necessary request. So I am a single parent and have 2 children. And so I just wanted to make the court aware that at least during individual voir dire, I will have to leave the courthouse by like 5:30 at the very latest, so I can pick my kids up by 6. And so I just kind of wanted to put everyone on notice. During the trial, they'll be up in North Dakota with family members before they come back for school. So that won't be an issue because I know at trial we have witnesses and stuff, but just during individual voir dire, I wanted to make
No,
the court.
we'll take care of you, actually. No problem.
And then Judge, one other
No,
thing
no.
with that,
Yeah.
my son has a doctor's appointment on July 22nd at 9 a.m. and he starts kindergarten. So I have to get his immunizations done so that he can start in August. So is there any way we could start a little late that morning?
We'll make accommodations.
All right, thank you, Judge.
Just remind me, okay?
Okay, wonderful. Thank you so
Yeah,
much.
That's not a problem. If anybody has any personal matters, life is life, and we're working, but it can be taken care of. Ashley, I do have one request from you, and that is that you already did it one time, and phonetically you had given me a way to pronounce your last name. Would you do that again for me,
Yep.
please? I don't know what I did with it.
So it's Puck
Mhm.
SHA
Okay.
VINSKI.
Thank you. I'm not going to lose it this time. Pukshavinsky.
Yep.
See there? That helps. All righty. What else, ladies and gentlemen?
That's all we have, Judge.
That's
Have
all
a
the
good-
state has.
Have a good day. We're adjourned.
Thank you,
Thank-
Judge.